Good afternoon. My name is Erwin Chemerinsky, and I have the enormous pleasure of being the Dean of Berkeley Law. And it's great to be able to welcome you to our Alumni Weekend. One of the traditions in Alumni Weekend is to do a Supreme Court panel. This is an amazing, but also a very difficult time to talk about the Supreme Court. Last term, there were an exceptional number of blockbuster decisions. The justices returned for the new term on Monday, October 5th, the first Monday in October. But there will only be 8 justices as the justices hear the first oral arguments. 2 weeks ago today, Justice Ruth Bader Ginsburg passed away at age 87. A replacement has been nominated. President Trump has nominated 7th Circuit Judge Amy Coney Barrett. The confirmation hearings are scheduled to start as soon as the week after next. So all of this is the context for talking about the Supreme Court last term and this term. We could not have a better panel to discuss it. I am going to do very short introductions of the panelists, and I apologize to them. They have incredible credentials, and I could spend most, if not all, our time relating that, but I hope they'll forgive me for just doing real short introductions. Our 4 panelists are going to be Easha Anand. She's Supreme Court and Appellate Counsel at the MacArthur Center. She's a graduate of Berkeley Law. She clerked for Paul Watford on the 9th Circuit and Sonia Sotomayor on the Supreme Court. Goodwin Liu is a justice on the California Supreme Court, graduate of Yale Law School, clerked for Judge David Tatel and Justice Ruth Bader Ginsburg, spent many years as a professor and as associate dean here at Berkeley Law. It's hard to believe, but it's almost a decade now that Justice Liu has been on the California Supreme Court. Petrol Ross is a Chancellor's Professor of Law here at Berkeley Law School, received his JD from Yale University, clerked for Dorothy Nelson on the 9th Circuit, Myron Thompson in the District of Alabama, and he's been a professor at Berkeley Law School for many years, specializing in constitutional law and election law. Amanda Tyler is the Shannon Cecil Turner Professor of Law, Berkeley Law School, graduate of Harvard Law School. She clerked for Judge Guido Calabresi on the 2nd Circuit, and clerked for Justice Ruth Bader Ginsburg. She specialized especially in the areas of civil procedure in federal courts, and among many other publications, has a new book that she's just finishing that she co-authored with Justice Ginsburg. That's the outgrowth of when Justice Ginsburg spoke at the law school last October. So our format is going to be to divide our time into 4 parts. In the first part, I'm going to ask each panelist to take 5 minutes and offer overall thoughts about the court, where it is now, where it's likely to go in the future, reflections on Justice Ginsburg, and what her passing means for the court. The second part of our program is going to involve each panelist having picked one case primarily from last term and explaining it and talking about why it matters. The third part of our program will be having each panelist take one case from the coming term and describe why it matters and talk about it in terms of what we should expect. And then the final part of the program, we're going to take the questions from our audience. Please feel free to send in the questions via the Q&A function, and we'll try to get to as many questions as we possibly can. So, without further ado, let me turn to the panelists. And Bertrall, I'll ask you first. What are your overall reflections on the Supreme Court, where it is, where it's going?
Thank you, Erwin. It's great to be here and great to at least be with you virtually, the alums of Berkeley Law. The Supreme Court is in I think, a precarious position right now. The Supreme Court has been, over the past few years, a court that's been pretty evenly divided between a more liberal set of 4 justices and a more conservative set of 4 other justices, with Chief Justice Roberts, who was understood or thought to be one that would align more with conservatives and has generally, but playing a more balanced role. I think he perceives his role as one of trying to preserve the legitimacy of the court by not allowing the court to get too far ahead of itself and too far ahead of the democratic preferences of the people. Now, of course, with the sad passing of Justice Ginsburg, that dynamic has shifted. And with the nomination of Amy Coney Barrett and her likely confirmation in the forthcoming weeks or months, the court is going to shift in a very conservative direction in which the Chief Justice will no longer be the swing justice on the court, but instead the court will be dominated by a block of 5 strongly conservative justices. Now, I don't know if this will lead necessarily to a revolution in the court's jurisprudence. The court's jurisprudence has been trending in a conservative direction for quite a long time. Sure, it hasn't overturned high-profile cases like Roe v. Wade, but if you look to its jurisprudence, it hasn't been protective of things that progressives really care about for a while. Instead, it has advanced a rather conservative agenda. Now, this last term was perhaps a little bit surprising in the fact that the court upheld a couple cases or ruled on a couple cases in ways that were favorable to progressives, but I think that doesn't necessarily indicate where the court is as an institution, and where the court will be is quite conservative going forward. Now, what I think that this means is I don't think you're going to see a dramatic change necessarily in what the court does. I don't think you're going to see an immediate overturning of Roe v. Wade. I think it'll be a little bit more of an insidious approach in which they seek to chip away at particular matters that go against perhaps the conservative value system. And I see this more insidious approach as being one that will lead to some complacency on the side of progressives who are now talking about presenting ideas of court packing and perhaps term limits. And what I predict is that those arguments may fade in the coming months, because I don't think the court will jump out of the gate as a very aggressive conservative court. Instead, I think it will be a slow progression. Now, that can all change depending on if the election is contested and goes to the Supreme Court. And if it does, and the court is involved in ways that would very much cut at its legitimacy, then there might be more proactive measures towards the court in the coming days. That's sort of how I see the court in terms of my limited time here. And I look forward to seeing how other panelists view the current state and the future of the court.
Thank you, Bertrall. Easha?
Thanks so much, Dean Chemerinsky, and it is a real honor to be here. So I think with my time, I'm not going to use the time reflecting on Justice Ginsburg's legacy, because my co-panelists, in particular Justice Liu and Professor Tyler, are kind of far better equipped to do that. And I'll also leave it to my co-panelists to kind of give you the big picture of just how dire things are looking for folks who are on my end of the political spectrum. So I think I'll just use my time to offer 3 thoughts kind of at the margins that are the sorts of considerations that wouldn't have occurred to me before I clerked at the court. So first, liberal successes since Justice Kennedy's retirement have come when they're able to win over one of 2 men, right? So either the Chief Justice, John Roberts, or Justice Gorsuch. Those 2 men are incredibly different. So the chief tends to give the liberals a vote when there's some real institutional interest on the line. So think the census case or DACA rescission. Justice Gorsuch has sort of a more libertarian sensibility, right? So his wins are a little more under the radar, but of tremendous importance. I'm thinking of cases like DeMaya, which was an immigration law case, Davis and Hammond, 2 crim cases about mandatory minimums and sex offender penalties, McGirt, an Indian law case that essentially made half of Oklahoma a reservation. And in previous terms, it's actually been pretty good that those 2 men are so different, because it means that there's twice as many cases where the liberals can count to 5. One set where Gorsuch is in play and a different set where the chief is in play. So because they're so different, more wins for liberals. But now that's actually a huge liability, right? So with one exception that we'll talk about later, it's actually going to be really rare that the kind of consummate institutionalist and the kind of legal arsonist who would burn it all down if the common law says to do it will see eye to eye. And so when you need to count to 6 instead of 5, rather than being an asset, those 2 very different jurisprudences are a real liability. And it's not clear to me what that Venn diagram looks like for liberals, where they'll be able to get 2 votes instead of just 1 to make a majority. So Weedsy thought number 2. one of the weapons that just got removed from the liberals' arsenal is their ability to force a grant. So as folks may know, only 1% of the petitions that come to the court are ever heard on the merits. It only takes 4 justices to grant a petition, right? And I can think of some cases in my term where it's actually pretty clear how the case is going to come out. The statute or the precedent is really clear. The opinion will be unanimous if the court hears the case. But because the issue only affects criminal defendants or immigrants or people of color or workers, there just isn't the momentum to get a grant. And so it was critical for liberal justices, just as a block of 4 without needing any other votes, to kind of set the agenda and force their colleagues to weigh in on some of these cases. And they just lost that power. There aren't even the 4 votes to get a grant from the liberals anymore. And so maybe I'll close with a sort of third weedy thought, which is I just want to offer a reminder of kind of how far we've come in just a few years, right? So to recap, the Chief Justice, John Roberts, architect of Citizens United and Shelby County and the war for arbitration, the Chief Justice is now part of the liberal wing of the court. He's not even a swing vote. You can't even start a conversation without him already on your side. And before that, the shift from Justice Kennedy to the Chief Justice as a swing vote, that was already a fairly dramatic change, right? So you see it in, for instance, June Medical, one of the abortion cases that was heard last term that Dean Chemerinsky is going to talk more about, where the chief joined the 4 liberals to cast a 5th vote. But in doing so, he effectively erased a case decided just 4 years earlier with Kennedy in the majority called Whole Women's Health. And so I think it's really critical to remember that the court has lurched right, not just because of Justice Ginsburg's passing, but because that passing has come just 2 years after Justice Kennedy's retirement. So we're not really starting from neutral ground here. And so I think that makes the situation even more dire. And I think, to Professor Ross's point, makes it even more incumbent on folks who identify as progressive to think about how to prevent the court from being a reactionary agent for a generation to come.
Thank you, Easha. Amanda?
Hi, and thank you, Erwin, for having me. Hello to all of our wonderful alums. I've now been at Berkeley Law long enough that I know I have some of my own former students in the audience, and it's great to sort of see you. I wish we were in person, of course. I'm going to wear both hats here, the federal courts professor and the former Ginsburg clerk. You know, some of the things that we've already discussed are, and that Bertrall raised, it's just so interesting that we find ourselves in a situation where the things that Erwin and I teach in federal courts to our students as, you know, far off hypotheticals are now getting very serious discussion. Things like legislating supermajority requirements, or how the Supreme Court decides constitutional cases. Many state constitutions have supermajority requirements in them, for example. Now expanding the size of the court is being discussed by serious people. That's something that's been off the table for a very long time. Term limits is being discussed, although Erwin and I have been discussing that for a few years now. You know, jurisdictional restrictions, all kinds of things that were just classroom hypotheticals are now in play, and it'll be very interesting to watch and see what happens in these next few years. Something that I would say as a general proposition, people need to be thinking about, apropos of Easha's comments, is that we're really going to see the importance now of looking beyond the federal courts, looking to state law, looking to state constitutional law, and looking outside the courts for legislative victories. Of course, those will only be as good as they can be insulated from federal court review, potentially. But we're living in a period that's a reminder that looking outside the courts is going to be increasingly likely important. I had the privilege, as Erwin said, of clerking for Justice Ginsburg, and it's impossible in 5 minutes, never mind an hour, to describe her legacy. Goodwin will probably say a few words on this as well. We both were privileged to be her clerk a couple of years apart, or maybe a year apart, I think. In any event, I've written up a tribute to her in the Atlantic that you might find interesting. Being her clerk, as I wrote there, was one of the greatest honors of my life. It was amazing to get to work with her then and to get to work with her also this summer when she was still correcting my work and teaching me how to be a better writer as recently as August. So her loss is personally devastating. I think it's devastating for the court. Her legacy was one both as an advocate and as a justice of constantly promoting a constitution that works for everyone, a constitution that includes everyone. She wrote in VMI about how ours is a constitution that is ever expansive in its inclusivity. And that was a central tenet of what she did as an advocate, of her work as an advocate, and of her time on the court. Another great legacy of her time on the court was her ability to really grapple with and appreciate that the decisions handed down by the court affected real people's lives on the ground. And she could relate in many cases we see to how the lived experiences of people in this country were affected by the rules and the decisions of the Supreme Court. Replacing her is, it's just, I mean, you can't replace someone like that. You can't replace someone with that history and with that background and that talent. She was brilliant among many other things. So it's really hard to think about a Supreme Court, and maybe for me it's just too close, but it's still just really hard to think about a Supreme Court without Ruth Bader Ginsburg on it. Maybe I'll stop there and hand the baton to Goodwin, who might have some things to add.
Thanks, Amanda.
Hello, everyone. It's wonderful to be in this Berkeley Law community again. I spent so many of my wonderful professional years as a professor there. I see on the participant list many of my former students. Wonderful to be with you and to be with the panelists, my colleagues, and with Easha as well. I'll just make a couple brief observations and then expand on what Amanda said about the late, great RBG. I do think Eisha's onto something with respect to the observation about the conservatives. One of the most interesting things I think is going to happen in the next period is observing the differences among the conservatives and seeing whether they can stick together or whether they're going to splinter. So you see Justice Thomas, the sort of pure originalist form of judicial conservatism. You see Neil Gorsuch, who purports to be an adherent to Scalia-esque textualism. You see John Roberts, who is the consummate institutionalist. You see Justice Alito, who is, I think, a lawyer's lawyer. He uses all sources and doesn't betray a kind of wooden adherence to any particular interpretive methodology. These tendencies pull in all kinds of different directions, as this most recent term demonstrates. That is how the liberals managed to catch a few votes in some of the key cases. And I just think it's kind of interesting that, you know, on the conservative side, this has been a 30-year quest or more, 40-year quest to get to this point. And over those 40 years, the evolution of conservative judicial philosophy has incarnated and reincarnated itself many, many times. It began with basic propositions about judicial restraint. Those couldn't withstand muster once a more muscular form of originalism took hold. Institutionalism has, you know, is a very double, triple, quadruple-edged kind of sword. And it's not obvious what is the unifying glue, apart from a commitment to, you know, certain kinds of results that advocates want, will unite the conservatives. So that's something just to watch as the new court takes shape. I'll just say a couple words about Justice Ginsburg. Most of what I have to say has already been written. I wrote a tribute to Justice Ginsburg, one in the Washington Post and another on SCOTUS blog, which you can read. Just a few anecdotes, really. It's really, as Amanda said, impossible to capture the life and legacy in just a few comments, but I'll just give you 3 vignettes from my time clerking. One was personal, which is that Justice Ginsburg was always really good on the personal stuff. She always sweated the small stuff. One example is the clerks had a basketball game on the top floor of the court every week, twice a week actually. That court is affectionately called the highest court in the land, literally on top of the Supreme Court building. One day I collided with a very genial but a very tall Scalia clerk, as fate would have it. And I came crashing to the ground and very badly sprained my ankle. I was immobilized basically for a couple months. And the very next day after this happened, I was laid up in bed, and the first phone call to come in to check on me was Justice Ginsburg. And this was significant not only because of the attention that she paid, but also because she was notoriously not a morning person. Her best hours were really, 1 to 4 in the morning, and then she would routinely sleep until 11 or 12 and get into the office in the afternoon. That was just her daily rhythm. So the idea that she would call me at a reasonable hour in the morning, I think was something memorable. And I think over the years, all the clerks and people who have known her can attest, no letter goes unanswered, nothing small gets past her field of vision. Second anecdote is that she was a meticulous writer and editor, which Amanda referred to. I remember once walking into her office when she wasn't there to go get something from a case file, and I just happened to notice on her desk an internal memo, just like a bench memo we would send to her. It wasn't going to be published or anything. And on that memo were these faint pencil marks catching like missing commas and little typos. And this was a surprise to me because she never returned these memos to us. This was her way of reading and just demanding perfection in whatever appeared before her eyes. And of course, we clerks were mortified at the thought that we would turn in anything that was, so riddled with errors. But this was instructive, of course, to me even now, that everything matters. Every stroke on the keyboard matters, and you should pay close attention. The last thing I'll just say is that I clerked for RBG during the Bush versus Gore year, which was obviously a very trying time. And you can just imagine, what kinds of conversations are happening inside the court right now as this election approaches. What I'll say about that experience is that Justice Ginsburg was just a paragon of calm temperament and collegiality and civility in a very difficult situation. And now, myself having been a judge and having disagreed with colleagues on things that matter far less than deciding the presidency of the United States, I have just such a deeper appreciation for the kind of mettle that it takes to remain cool, calm, and collected in a very difficult situation. And that was a great model for all of us. So I'm personally going to miss her tremendously. I know the country is going to miss her tremendously, and the court will never be the same.
Thank you. I just want to offer a couple of observations about the court, one about last term and one about the coming term and the longer term future, and then we'll begin discussing specific cases. In terms of last term, I guess the question can be asked, why was last term different from all other terms? Because in many ways it was. The Supreme Court decided fewer cases last term than in any term in recent memory. The court decided 50 with signed opinions after briefing and oral argument. That's the fewest number since 1862, early in the Civil War. Also, in terms of last term, the court canceled oral arguments in March and April. The last time the court did that was on October 1919 during the Spanish flu. The court rescheduled 10 of those cases to be heard in May, and they were argued over the telephone. Obviously, the first time there's ever been telephonic oral arguments in the Supreme Court. The Supreme Court did live audio broadcasts of those telephonic oral arguments. The court has been so resistant to any video or audio broadcast. This is the first time that's happened. And I hope that even when the justices return to the majestic courtroom, they'll continue to have live broadcasts so we all can participate by listening. And it was also an extraordinary term because one justice so dominated, Chief Justice John Roberts, in 97% of all the decisions. He dissented only twice all term. And as you know, if the chief is in the majority, the chief assigns who writes the majority opinion. And he assigned to himself writing some of the most important majority opinions of the term. My second observation looks to the future. And what does the loss of Justice Ginsburg, for almost certain replacement by Judge Amy Coney Barrett, mean for the future of the court? Of course, as others have spoken, it's an enormous loss to the court in terms of her vision, her voice, her commitment to excellence. What about in terms of decisions from the court? It's significant, but I also don't want to overstate it. Last term, there were 14 5-4 decisions of the 53 cases. In 10 of the 14 5-4 decisions, the majority was Roberts, Thomas, Alito, Gorsuch, and Kavanaugh. In 2 of the majority was Roberts, Ginsburg, Breyer, Sotomayor, and Kagan. To be sure, those 2 cases were very important. It's where the court invalidated President Trump's rescission of DACA, deferred action for childhood arrivals, and where the court struck down the Louisiana law restricting abortion. I think both of those cases surely would have come out differently if it was Amy Coney Barrett in that seat rather than Ruth Bader Ginsburg. But the reality is, for the vast majority of ideologically divided cases, replacing Ginsburg with Barrett means it's going to be 6-3 rather than 5-4. I think in order to assess what it means to replace Ginsburg, we need to put it in a slightly broader context. There have been 2 important vacancies in the last couple of years. And I think we need to look at what does it mean they've been replacing both Justice Kennedy and Justice Ginsburg in a relatively short period of time with justices who are much more conservative than those who they replaced. With regard to abortion, I think without question, there are 5 votes to overrule Roe versus Wade. Prior to September 18th, I would have said there were 4 votes, Thomas, Alito, Gorsuch, and Kavanaugh. And I have no doubt whatsoever that Amy Coney Barrett will be the 5th. I think there well could be 5 votes to declare the Affordable Care Act unconstitutional, something that's going to be argued to the court the week after the election. Amy Coney Barrett was very critical of the Supreme Court's decision in 2012 that upheld the Affordable Care Act. Without Justice Ginsburg, it may be the court will be striking down this law. Gay and lesbian rights. The majority opinion in every constitutional case expanding gay and lesbian rights was written by Anthony Kennedy. Every one of those cases had Ruth Bader Ginsburg in the majority. I think now there's going to be a majority of the justices, who at the very least will allow individuals, businesses, employers, who have religious objections to discriminate against gays and lesbians, including in the employment context. Affirmative action. There might have already been 5 votes to say that the government can't engage in any forms of affirmative action, but now I'm sure there's a majority of the court to eliminate all forms of affirmative action. These are just a few examples. And I guess I'd conclude my general remarks by saying this isn't going to be a short-term change in the composition of the court. Amy Coney Barrett is 48 years old. If she remains on the court until she's 87, the age with Justice Ginsburg passed away, Amy Coney Barrett will be a justice on the United States Supreme Court into the year 2059. Neil Gorsuch is 52, Brett Kavanaugh is 54, John Roberts is 65, Sam Alito is 70, Clarence Thomas is 72. So we're looking at a real possibility of a very conservative court for a decade or 2, maybe more. That's the context along with what my fellow panelists have said, and I think we should focus on the case from last term. Easha, could I turn to you to talk about Bostock versus Clayton County, Georgia?
Sure. I'll say a few words about Bostock, and then I want to talk as well about a case that's perhaps a little unexpected, which is a case called City of Escondido versus Emins. So I won't dwell on Bostock because it's a case that really made headlines and the significance of which is really clear to everyone in the country. So Bostock is the really remarkable case, and the exception to the rule I mentioned earlier about the Chief and Gorsuch having no Venn diagram overlap, because both signed on to a 6-3 opinion holding that firing someone for being gay or transgender violates Title VII's protections against discrimination, quote, because of sex. Now, there's been a lot of kind of speculation that this case is somehow a Trojan horse, that expanding the notion of what it means to discriminate on the basis of a protected characteristic is going to provide a window to strike down affirmative action programs in the future. And there may be repercussions to this case down the line, but for now, massive numbers of people around the country are going to have a measurable difference in their lives and livelihoods because of Bostock. I also want to spend a little bit of time talking about a case that was one of last term's sum revs. So it's called City of Escondido versus Emins. Sum rev is short for summary reversal. And it's this summary reversals are sort of the set of cases that the court thinks are so easy that it's going to decide them not only without argument, but without even briefing on the merits of the question, only with briefing on the question of whether or not to grant cert. And in this particular case, not even full briefing on that question because the city didn't even file a reply in support of certiorari. And I want to focus on this case because in stepping in to reverse in this case, the Supreme Court continued a campaign it started roughly a decade ago to aggressively root out and reverse, often summarily, any opinions imposing liability on a police officer for using excessive force, for beating, tasing, shooting, killing, often Black men, sometimes women. And the way the court does that is it summarily reverses on the ground that the officer was entitled to qualified immunity. So what's qualified immunity? Well, the answer is that it kind of depends. So back in the 19th century, some kinds of public officers doing some kinds of acts were able to put forward a quote unquote good faith defense to liability. So I relied on the statute. It turned out to be unconstitutional, but I had no way of knowing, or I consulted an attorney who said I could do this. So fast forward from the 19th century to the 1980s, and the Supreme Court holds that Section 1983, which is a sort of all-purpose civil rights statute passed during Reconstruction, that statute incorporates this good faith defense. And in the half century since, that defense has really kind of hulked up even more, and it's gotten to the point where unless a plaintiff can point to a case squarely holding that what an officer did was unconstitutional, the officer is entitled to qualified immunity and needn't stand trial. And when I say a case on point, I mean a case on point, right? So if a cop sicks an attack dog on someone sitting on the ground with their arms up in surrender, it's not enough that there's a case saying it's unconstitutional for a cop to sick an attack dog on someone who is lying down and who is surrendered. Qualified immunity. Or if one case holds that keeping an inmate in a cell covered in feces for 2 weeks violates the 8th Amendment, the correctional officer who keeps an inmate in a cell covered in feces for 1 week entitled to qualified immunity. And these are not hypotheticals. These are actual cases that were kicked on qualified immunity grounds. And the Roberts Court has become this sort of iron fist on this. So whereas ordinarily they only pay attention to cases involving a circuit split, so that is where the lower courts are kind of in disarray, those criteria are out the window when it comes to qualified immunity. There's not even a pretense that these cases amount to anything other than correcting an error, but because it's an error that might lead to holding a police officer accountable, the Supreme Court steps in. And these summary reversals are, for the most part, unanimous. Sometimes Justice Sotomayor dissents, but in City of Escondido from this past term, that was a unanimous case. So last spring, it kind of looked like there was sort of going to be this ray of light through the shadow of the Supreme Court over police brutality suits, to sort of totally mix my metaphors. The combination of the incredibly powerful Black Lives Matter movement and our sort of national reckoning with race, combined with some really exceptional scholarship about just how far astray from the common law, how ahistorical and atextual, those are kind of originalist bogeymen, just how ahistorical and atextual qualified immunity had gotten, seemed to create this kind of window of possibility, right? And so you had both Justice Sotomayor and really remarkably, Justice Thomas calling for the court to revisit this doctrine. And a dozen or so petitions with really egregious facts, like the ones I just described, asked the court to overrule qualified immunity. And after a lot of rescheduling that kind of gave everyone in the civil rights community a lot of hope, those cases were denied without any noted dissent except from Justice Thomas. I don't know.
If you could, I so apologize that if you could just finish up because we have to get all these cases in.
Of course. So I just wanted to close on that sort of less hopeful note that there's been a decade-long campaign of these slapdowns that has made circuit courts incredibly wary of denying qualified immunity, and it looks like that's not going to stop anytime soon.
Thank you. And again, I apologize. Amanda?
Sorry, I had muted myself. To the surprise of no one who has taken a class from me, I'm going to talk about a habeas case. Specifically, I'm going to talk about Thurassingham, Department of Homeland Security versus Thurassingham. I think this is a really important case on its own terms, but also with respect to looking ahead. It highlights that this is a court that is already shifting its in its jurisprudence. And it also highlights, I think, how important it is who is in the Oval Office, because as I will explain, the decision leaves a lot of room for very aggressive action in the immigration context by the executive branch. So this is a suspension clause case, a topic on which I've written quite a bit. And it involved suspension clause and due process challenges to restrictions on the ability of asylum seekers to obtain review of expedited administrative removal proceedings. The case starts when Thurassingham crosses into the United States without going through a border checkpoint. So he crosses in a clandestine fashion, and he is apprehended by a Border Patrol agent 25 yards into the country. Now, at that point, he seeks asylum, and the administrative proceedings as they exist gave him various hearings before immigration officials. He tried to make a claim that he had a credible fear of persecution if he was returned to his native country of Sri Lanka. And if he had succeeded in that regard, he would have been taken out of the expedited removal process. However, he did not. He did not convince the immigration officials that he had a credible fear of persecution. And for that reason, he was put into expedited removal. At that point, he files a habeas petition, arguing, among other things, that the immigration provisions that purported to restrict federal court review of his case and that did not allow him for more hearings to make out a credible fear case were a violation of the suspension clause. And basically what he wanted was a new opportunity to present his asylum claim before administrative officials. And ultimately, of course, what he's seeking is entry into the United States. In an opinion for 5 justices, Justice Alito, writing for the court with Roberts, Thomas, Gorsuch, and Kavanaugh joining him, basically rejects all of Thurassingham's arguments across the board. Some very interesting things happen in the majority opinion. Alito posited, that the court's inquiry should ask how the founding generation understood the suspension clause in 1789. Now, this is something about which I've written an entire book and quite a few articles. I find it, I will stop here at this threshold issue and say, I find it very interesting that Alito focuses on this question because there were no immigration restrictions for much of early American history. So how the suspension clause, if at all, applied in the immigration context is a question that really was on no one's mind in 1789 when the Constitution was ratified. Nonetheless, he went on to say that Thurassingham's claim failed because he was not seeking release. That was the classic remedy in terms of habeas connected, or the idea of habeas that was connected to the suspension clause. Alito goes on to say, what he's really seeking is more process, and that is something that the suspension clause is not concerned with. Here, I will pause and say, Alito, and this is one of the noteworthy aspects of this case, Alito's decision is not on this point in keeping with the court's decisions in Hamdi and Boumediene, the two enemy combatant cases, where the court did, as a matter of the suspension clause, order more process, not release. So we see the court moving precedentially now away from those decisions. The final and major aspect of the majority opinion that bears note is the fact that the court highlights that they don't believe he was in the United States. Petitioner was in the United States when he was captured. Doesn't matter that he'd crossed the border. The court says that Congress has plenary authority to regulate in this field, and Congress has designated someone like that as being, for all intents and purposes, outside the United States. And as such, the court says that any due process claims he would assert are due process claims that would be judged on the understanding that he is asserting them from outside the United States. Now, this is significant. This is significant because when you combine the decision in Thurassingham with the court's last term's decision in a USAID case, what we see there is that the court talked about how those who are foreigners and are outside the United States have almost no constitutional rights. That's an opinion by Justice Kavanaugh. So if you combine those two decisions, what you see is that some very, in my view, scary hypotheticals could become real cases. And these are hypotheticals that are put in the in Justice Breyer's and Justice Sotomayor's decisions. Breyer and Ginsburg have a narrow concurrence, and Sotomayor dissents. But Breyer talks about the fact that, under the logic of these two decisions, someone who has come into the United States, not through the ordinary channels, and has built a life here, could potentially be treated as having never entered the United States and could be removed through expedited proceedings. And this is not a far-fetched hypothetical because existing law issued by the Trump administration dictates that non-citizens who've lived in the United States for up to 2 years can be placed in expedited removal proceedings. So this is a decision that didn't get a huge amount of press, but I think it's potentially a very, very significant decision. And I've gone over, so I'll stop there.
Thank you. Goodwin?
Terrific. So I'm going to talk about the subpoena cases, Trump versus Vance and Trump versus Mazar. These two, just to situate them, are part of a quartet of cases, decisions authored by Chief Justice Roberts on executive power. The other two I'd put in this category are the DACA case and the Consumer Finance Protection Bureau case, Celia Law. So I think, one notable thing is the extremely prominent role of the Chief Justice in regulating the role of the court vis-a-vis the executive branch this past term. In the Vance case, the Manhattan DA opened an investigation into possible wrongdoing by the president's business organizations in 2018, and then in 2019 issued a subpoena in the context of a criminal investigation seeking financial records from the president's personal accounting firm, Mazars. Trump then sued the Manhattan DA and Mazars to enjoin enforcement of the subpoena on the ground that he essentially could not be served with this process while a sitting president. All 9 justices in the case reject the proposition that the president is absolutely immune from federal criminal process while serving as president. So that's an important first proposition, that the president, in a sense, is not above the law with respect to federal criminal process while sitting as president. Chief Justice Roberts writes for a 5-justice majority to say that not only is he not immune, but because there is no claim of executive privilege with respect to these documents, these are, after all, personal or organizational financial records. They're not documents that relate to the deliberations of the executive branch over which there could be executive privilege. because they are outside the executive privilege, there is no need to apply a heightened standard. No, the principal case on this had been United States versus Nixon, the case seeking the tapes, and the standard there had been a demonstrated specific need for the evidence. Here, mere materiality is deemed to be sufficient, just as it would be in an ordinary criminal case. So that too is very significant, that Chief Justice Roberts assimilates what's going on here to just ordinary procedure. But he doesn't stop there. He does note that the president, of course, is a unique office holder in our government, and says that essentially the procedure used to go about the subpoena has to respect the fact that the president has constitutional duties that he must discharge. And so the subpoena can't be undertaken in a manner that would frustrate the president's execution of those official duties, and all the usual state law defenses to compliance with the subpoena: undue burden, bad faith, improper motive, overbreadth, all of these things still apply. So that case got sent back to the courts below to essentially have further litigation over the specifics of how the subpoena is going to be carried out, and that litigation is ongoing. Notably, the case did not decide the sort of ultimate question of whether a sitting president can be subject to criminal prosecution. That has not been implicated, and the court expressed no view. In the other case, the Trump versus Mazar's case, it was combined with another case called Trump versus Deutsche Bank, but they emanate from the same basic problem, which is that in these cases, 3 House committees issued 4 subpoenas for similar kinds of information as in the Vance case: financial records, business records, accounting records from third parties, Deutsche Bank, Capital One, and Mazars, that held Trump and Trump Organization papers. So this concerns the legislative subpoena, the power of the House of Representatives to get documents from the executive branch. The court, through Chief Justice Roberts, in a 7-2 decision, essentially says that historically, these kinds of disputes between the two political branches of government have been resolved through negotiation, compromise, and political interaction, rather than through the courts. And Chief Justice Roberts notes that this is the first time, actually, that this issue has actually come to the Supreme Court. And so he is very careful to say, I don't want to put my toe in very deeply into this, because historical practice suggests that the political branches are able to work this out themselves without judicial involvement. Second thing he says is that Congress undeniably does have the power to collect information relevant to a valid legislative purpose. And there must be a valid legislative purpose in order to have an underlying subpoena serving it. Third thing he says is that, again, here, as in Vance, there is no claim of executive privilege. So no heightened standard of demonstrable specific need, or that there is a demonstrably critical need for the information has to be shown by the Congress. The fact that, fourth, I'll say one more thing, the fact that the president's papers are being sought with respect to papers in his personal capacity, the court says, doesn't remove this case, however, from the basic constitutional concerns about the separation of powers, because the president is a unique office holder insofar as he is a single person who, in a sense, incarnates the executive branch of government. So Chief Justice Roberts is trying to carve a middle path here, and basically says in the end, lower courts, go back and think harder about how whether or not the subpoena served a valid legislative purpose, whether it was truly related, not just as a case example for general legislation, but whether or not there was a real need for the president's papers with respect to the legislative purpose. And here the purposes were things like considering legislation related to money laundering, disclosures of people seeking office for president, and the like. So this case also got sent back for further review. The basic idea of both of these cases is that the president is not above the law, but the courts are going to step in only very carefully.
Thank you. Bertrall?
Thank you. So I'll be speaking on Department of Homeland Security, the Regents of the University of California, which was a case that involved a challenge to the rescission of DACA by the Department of Homeland Security under the Trump administration. And this case is along similar lines and ilk of the cases that Goodwin just described, Mazar's and Vance, and it also shares some commonalities with the census case that was decided the previous term. So in the summer of 2012, the Obama administration's Department of Homeland Security announced the creation of DACA, Deferred Action for Childhood Arrivals program. DACA had two components. First, it allowed certain unauthorized immigrants who entered the United States as children to apply for a 2-year deferral from removal. And second, those granted such relief received eligibility for work authorization and various other federal benefits. In 2017, the Trump administration's Attorney General advised the Department of Homeland Security to rescind DACA based on its conclusion that the program was unlawful. And the acting secretary for the Department of Homeland Security followed up by issuing a memorandum terminating the program. Individuals and other parties affected by the termination of DACA then claimed that challenged the rescission, claiming that the rescission of DACA violated the Administrative Procedures Act. So under the Administrative Procedures Act, agencies are required to engage in reasoned decision-making, and the act mandates that agency actions be set aside if they are arbitrary or capricious. Now, the original explanation that the Attorney General, Acting Secretary of Homeland Security provided for the rescission of DACA was that DACA was illegal. The department attempted to supplement its explanation for the rescission after the DC Circuit Court vacated the rescission, but the Supreme Court found that these potentially post hoc rationalizations could not be considered in the arbitrary and capricious review. So the Department of Homeland Security was stuck defending the rescission on the basis of its original determination that DACA was illegal. Now, the Attorney General advised the Department of Homeland Security that DACA was illegal on the basis of an earlier Fifth Circuit determination declaring the Obama administration's Deferred Action for Parents of Childhood Arrivals, or DAPA, illegal. The Department of Homeland Security argued that on the basis of the similarities between DAPA and DACA, it could rescind DACA as similarly illegal. Now, the court, in a 5-4 opinion that was authored by Chief Justice Roberts, disagreed. And in doing so, the court started by identifying the two separate components of DAPA and DACA. The first involves the provision of federal benefits for those granted deferred action. And it was the granting of these benefits to DAPA recipients that the Fifth Circuit Court of Appeals found illegal. And DACA's provision of these benefits could also be rescinded on that basis. But DAPA and DACA provided more than the conferral of federal benefits. It also provided for the temporary non-enforcement of immigration laws to DAPA and DACA recipients who were considered to be low priority illegal aliens. The Fifth Circuit in its adjudication of DAPA did not address the legality of this forbearance component of the program because the states in the case did not challenge the Secretary's decision to decline to institute proceedings, terminate proceedings, or decline to execute a final order of deportation. And as a result, insofar as the Attorney General in his advice to the Department of Homeland Security relied on the Fifth Circuit decision, it failed to address the legality of the forbearance policy, which the court determined was at the heart of DACA. It did not compel the Department of Homeland Security to abandon the policy. So the Acting Secretary of Homeland Security still held the discretion to continue or to discontinue the forbearance policy, but the APA requires that the Secretary provide a reason for the termination, and the memorandum terminating DACA failed to provide a reason for terminating the forbearance policy. Instead, the Secretary treated the Attorney General's conclusion regarding the illegality of benefits as sufficient to rescind both benefits and forbearance without explanation. So what does this all mean going forward? Well, the decision certainly did not insulate the DACA program from termination. The department can, in a second Trump term, if that were to occur, likely will, pursue a rescission action relying on some of the reasons that the court did not allow the department to enter into the record in this case.
The court could have provided DACA with some constitutional insulation by finding that the program violated the equal protection component of the Fifth Amendment due process clause, but the court found the evidence of discriminatory intent inadequate, which included evidence of disparate impact, the unusual history leading up to the rescission, and critical statements made by Trump against Latinos in particular. So I'll conclude on that note. What this all means is that the executive branch has to follow process and has to provide explanations for its decisions. Failing to do so will violate the APA arbitrary and capricious program, but the administration and the executive branch still retains the discretion to engage in these types of acts. Thank you.
Thank you, Bertrall. The cases that I especially want to focus on from last term involve the Constitution and religion. I think we are now a shift on the Supreme Court with regard to religion. I think we have a majority of the justices who reject any idea of a wall separating church and state. The majority of the justices who want to aggressively protect free exercise of religion, even when it's empowering people to discriminate against others. There were two cases from last term I want to mention. One is Espinoza versus Montana Department of Revenue. The Montana legislature adopted a law that gave a tax credit up to $250 for those who gave money to a private school tuition organization. Almost all of the private schools in Montana are Catholic or evangelical Christian. The Montana Supreme Court found that this violated the Montana Constitution. Montana, like most states, has a state constitutional provision forbidding direct or indirect aid to religion. Now, I would have thought this would have ended the litigation. The Montana Supreme Court found a Montana law violated the Montana state constitution. It couldn't be said that Montana was discriminating against religion. There was no program any longer. But the Supreme Court, in a 5-4 decision, reversed the Montana Supreme Court. Chief Justice Roberts wrote for the court, joined by Justice Thomas, Alito, Gorsuch, and Kavanaugh. Justices Ginsburg, Breyer, and Sotomayor wrote dissents that Justice Kagan joined. Chief Justice Roberts said, whenever the government gives benefit to private secular institutions that denies to religious organizations, the government must meet strict scrutiny. Its action must be necessary to achieve a compelling government purpose. The bottom line of this is, whenever the government gives money to private secular schools, other private secular organizations, it is constitutionally required to give that aid to religious schools or religious organizations, unless doing so would violate the Establishment Clause. And for the conservative justices, very little violates the Establishment. In 2017, in Trinity Lutheran versus Comer, Justice Sotomayor said never before had the court required the government to give aid to religion. Now I think that's going to be a widespread practice, a requirement imposed in many contexts. The other case that I want to mention is Our Lady of Guadalupe School versus Morrissey Baru. It involves two lay teachers at Catholic schools. One was a woman who had breast cancer and took time off work. When she wanted her job back, she was told it had been filled. She sued the school under the Americans with Disabilities Act. The other involved a lay teacher who said he was fired to hire a younger teacher who'd be less expensive. He sued under the Age Discrimination and Employment Act. In 2012, in Hosanna Tabor versus EOC, the Supreme Court held that a religious school could not be held liable for the choices it makes. That case involved a religious school that ordained its teachers as ministers in the faith. The Ninth Circuit, in the Guadalupe school case, distinguished that and said, these teachers are not ministers. The Supreme Court rejected that distinction. Justice Alito wrote for the court, 7-2. Justice Sotomayor wrote the dissent, joined by Justice Ginsburg. Justice Alito said that a religious school cannot be held liable for the choices it makes as to be its teachers. So long as the teacher plays any role in teaching or modeling religious behavior, the religious school can't be sued. Justice Sotomayor pointed out in her dissent, this means that religious schools are completely exempt from all employment discrimination law. They can discriminate based on race, sex, religion, sexual orientation, disability, age, with impunity. And so you see here in both of these cases, the conservative justices substantially expanding free exercise protections. I just want to take a few seconds and refer to the abortion case from last term. It's June Medical Services versus Russo. It involved Louisiana law that said that in order for a doctor to perform an abortion, the doctor had to have admitting privileges within 30 miles. If that sounds familiar, it's because 4 years earlier, in Whole Women's Health versus Hellerstedt, the Supreme Court declared unconstitutional an identical law. That case was 5-3, with Breyer writing, joined by Kennedy, Ginsburg, Sotomayor, and Kagan. Alito dissented, joined by Roberts and Thomas. Many wondered, what would the court do without Justice Kennedy? To the surprise of many, the Supreme Court 5-4 invalidated the Louisiana statute. Breyer wrote for a plurality of 4, joined by Ginsburg, Sotomayor, and Kagan. He repeated his analysis from 4 years earlier. Chief Justice Roberts was surprisingly the 5th justice for the majority. He concurred in the judgment. He said he disagreed and still disagreed with that ruling, but he felt bound to follow stare decisis precedent, so would vote to strike down the Louisiana statute. Each of the dissenting justices wrote a strong dissent. This is one of the cases that would have come out differently if Ruth Bader Ginsburg wasn't on the court, if Amy Coney Barrett was there instead. Well, with that, let's transition to talking about the term that starts on Monday. Here I'd ask each panelist to take no more than 4 minutes to discuss his or her case. And Amanda, if I could start with you.
Sure, Erwin, thank you. So I will speak briefly. I am going to talk about a civil procedure case. And I can't help it because, especially in an event where we're talking about the Supreme Court and we're talking about Ruth Bader Ginsburg, she would have loved this case. I imagine she was working on it before her death, and we would have likely seen an opinion from her in this case. So it's actually 2 cases, Ford Motor Company versus Bandemer and Ford Motor Company versus Montana's 8th Judicial District Court. The cases combined are really important personal jurisdiction cases, and I tentatively chose these cases because I know for some of you, maybe studying personal jurisdiction was a really traumatic entry to law school. But there's a question that has long loomed in the jurisprudence that the court has never answered. And it's a very important question. Namely, how close a connection does there have to be between a defendant's contacts with a state and the actual cause of action at issue? So more specifically, to give an example of how these cases fall in the crosshairs of this issue, in one of them you have someone purchased a second or a used Ford vehicle and it rolled over and caused great injury. In that case, if I'm not mixing up the cases, caused death. The estate wants to sue Ford Motor Company. The car was purchased secondhand in the relevant state. It was driven in the state and used by the downstream purchaser in that state. But the original sale of the car as a new car directly from Ford occurred out of state. And so Ford says that it should not be subject to personal jurisdiction under those circumstances in the state in which the individual was killed and the accident occurred. The cause of action, among other things, argues about design defects and other things, makes allegations about design defects and other things. So for a long time, the court members have talked about specific personal jurisdiction lying where a cause of action arises out of or relates to the defendant's contacts with the forum. Well, in this case, the defendant's contacts with the forum, Ford's contacts, are its advertising, its promotion of new car sales, its support of used cars through Ford dealerships providing servicing, Ford dealerships providing parts and other things of that nature. So certainly those activities relate to the cause of action, but the car itself was sold by Ford in another state initially. And so Ford says in this situation, we can't be subjected to the jurisdiction of the downstream state's courts. If the court agrees with Ford's position, you're going to see a big limitation on the exercise of personal jurisdiction over defendants, and you're going to see even more to the point, I think a huge amount of litigation, satellite litigation now, about what it means to arise out of, how tight a connection that is. There needs to be between a lawsuit and the defendant's contacts with the state. Going the route of general jurisdiction is not going to be an option, because actually in opinions by Justice Ginsburg, most notably the Goodyear opinion from a few years ago, the court has dramatically scaled back opportunities to find general jurisdiction for unrelated causes of action against defendants who do a sizable amount of business in the state. So this is a very important case, and it will have very significant ramifications on the law of personal jurisdiction, and more generally, obviously, a plaintiff's ability to choose among various potential fora to bring suit. So this is a case that may not, again, like my other case, get a lot of attention in the press, but it's one worth watching, because however the court decides it, and in the absence of Ginsburg, it may decide it in favor of Ford, it will have very significant ramifications going forward. Thank you.
Thank you, Amanda. Goodwin?
Thank you. I want to just speak briefly to one juvenile justice, criminal justice case on the court's docket, Jones versus Mississippi. So Jones versus Mississippi concerns juvenile life without parole sentences. This is an area of law that traces back now 15 years to a whole slew of cases that the court has decided, recognizing the mitigated culpability of juveniles for very serious crimes. It began in 2005 with the Roper versus Simmons decision, which held that juveniles cannot receive the death sentence for homicide crimes that they committed as juveniles. And then Graham versus Florida shortly thereafter, which held that juveniles can't be sentenced to life without parole for non-homicide crimes. And then a decision, Miller versus Alabama in 2012, which held that states cannot sentence juveniles to mandatory life without parole sentences. There must be an individualized consideration of the circumstances of that particular juvenile and the crime before an LWOP sentence can be given. The Miller decision was made retroactive in a more recent decision called Montgomery versus Louisiana. So today there are over 2,000 people in prison with LWOP sentences based on crimes they committed as juveniles. The case Jones versus Mississippi concerns what kind of finding must be made by the sentencing court in order to impose an LWOP sentence on a juvenile. Up till now, there has been some confusion in the lower courts about whether an express finding of incorrigibility, permanent incorrigibility, must be made by the sentencing court before imposing this quite draconian sentence. And there is reason to believe that the court, having granted this case, it is poised to require, in essence, an express finding by the sentencing court that the juvenile is in fact incorrigible. And this is important because in Miller versus Alabama, the court said that juvenile LWOP sentences should be rare, that it should be an uncommon practice. And the advocates in these cases have argued that Miller has been, in a sense, under-enforced because sentencing courts have not heeded sufficiently Miller's admonition to make these sentences rare. And the idea that there must now be some kind of express finding, presumably reviewable for substantial evidence or a similar standard, would be a significant additional procedural measure in this line of cases. This is also an interesting line of cases because it shows the way in which science has affected the court's jurisprudence. As Justice Kagan, I believe, said in one of these cases, there's been voluminous science on the brain development of adolescents and young people that has radically reshaped this area of law, not just in the Supreme Court, but also in the states. Even though this science, as she put it, confirms what every parent knows, that juveniles are impulsive, that they have great susceptibility to peer pressure. They are vulnerable to substance abuse. They can't connect actions to consequences. The fact that there has developed a very robust set of studies that in black and white scientific findings support these basic intuitions has been a significant factor in orienting the court's jurisprudence in this area.
Thank you. If I remember right, both Graham versus Florida and Miller versus Alabama 5-4 with Justices Kennedy and Ginsburg in the majority.
That's true.
And it's just Bertrall.
Thank you. So the case I'm going to describe for this term involves California v. Texas. And it's a question about the constitutionality of the amendments to the Affordable Care Act shared responsibility payment, otherwise known as the individual mandate. So in the 2012 case of NFIB v. Sebelius, 4 members of the court and Chief Justice Roberts held that the individual mandate exceeded Congress's power under the Commerce Clause and the Necessary and Proper Clause, because Congress could not, pursuant to these powers, compel individuals to purchase health insurance. But then a different 4 members of the court and Chief Justice Roberts proceeded to uphold the individual mandate as a proper exercise of Congress's taxing powers. So what followed was repeated efforts by congressional Republicans to repeal the ACA. And these efforts picked up steam after Trump won the presidency. But despite controlling the presidency and the 2 chambers of Congress, the Republicans could not get a repeal over the finish line. So in the 2017 Tax Cut and Jobs Act, Congress instead set the shared responsibility payment amount under the Affordable Care Act to 0. After setting the payment to 0, 2 private citizens and 18 states sued several federal defendants. And the plaintiffs claimed that the amended individual mandate exceeded Congress's constitutional authority because a shared responsibility payment still somehow compelled individuals to purchase health insurance and therefore still exceeded Congress's Commerce Clause authority. But it also, because it did not require anybody to pay anything, should not be considered a tax because it didn't generate revenue for the government. So as a result, the individual mandate exceeded Congress's taxing power as well. So the case raises 3 major questions. The first is whether the plaintiffs have standing. Second, if the plaintiffs have standing, whether the reduction of the shared responsibility payment to 0 exceeds Congress's constitutional authority. And third, if the reduction of the shared responsibility payment to 0 exceeds Congress's constitutional authority, can the individual mandate provision be severed from the other provisions of the ACA or must other parts of the Act be declared invalid along with the individual mandate? Now, I'm going to put the standing and severability questions aside, happy to engage them in Q&A, and instead focus on the constitutionality of the amended shared payment shared payment, which is an unusual question. It'll be interesting to see how the court ultimately responds to this issue. Now, on first glance, it might seem straightforward with respect to the taxing argument, whether it's a constitutional exercise of congressional taxing power, that perhaps the individual mandate should be declared unconstitutional. A central basis for the court's determination that the individual mandate was a tax was because it generated revenue. A shared responsibility payment set to 0 does not generate revenue and therefore cannot be considered a tax under that logic. Now, the defenders of the law advance arguments that it should be treated as a suspended tax that Congress can revive to generate revenue in future years if it chooses to do so. And the defenders cite to other suspended taxes that have not been challenged or declared unconstitutional. Now, I'd be curious to hear what others think, but on its facts, this does not seem to be a particularly persuasive argument for defending the constitutionality of the amended shared responsibility payment. The stronger defense, in my opinion, centers on the argument that by setting the shared responsibility payment to 0, the Act is now a permissible exercise of Congress's Commerce Clause authority. Now, recall that in NFIB v. Sebelius, the court held that the individual mandate exceeded Congressional Commerce Clause authority because it compelled individuals to enter the market for health insurance. A shared responsibility payment set at 0 changes the law from one of compulsion to one of encouragement, since there are no consequences associated with the failure to purchase health insurance. And Congress, consistent with precedent, can encourage individuals to do things pursuant to its authority under the Commerce Clause. One of the foundational Commerce Clause cases, I'm sure you all remember from law school, Filburn v. Wickard. The court upheld a law that had the effect of encouraging a wheat farmer to enter the consumption market for wheat. And similarly here, the ACA is now a law that encourages individuals to enter the consumption market for health insurance. And so we'll see how that turns out, but that's kind of the main constitutional question. I think there are viable standing issues that could allow the court to dismiss the case. And the severability argument that the challengers put forth, I don't think it's particularly persuasive. I think you can make an argument that it can be, the individual mandate, if it is unconstitutional, can be severed from the rest of the act now that we see that the act in operation can function fine without an individual mandate. So I'll be curious to see, and this is one that Democrats are paying attention to and will be a subject of conversation during Barrett's confirmation hearings.
Easha?
So the term hasn't even officially started, right? So the traditional kickoff day is the first Monday in October, 3 days from now, but we have already seen a slew of important cases bubbling up to the court in at least one arena, which is voting rights. So, dating back to Bush versus Gore, where the Supreme Court essentially decided an election, the Supreme Court has always seen its share of election law cases, but this year, thanks to COVID and how quickly it's requiring states to change all sorts of rules, we're on track to see a really unprecedented number of cases. By one count, there are 300 election lawsuits in 40 different states right now. So the court has historically decided these cases in a really expedited state posture, which means there hasn't been much writing on why the court is deciding the way it is. But what little writing there is talks a lot about something called the Purcell Principle. And the Purcell Principle is basically something like, you shouldn't change the rules of an election too close to when voters are casting their ballots, because if you do, there will be so much voter confusion that you will wind up disenfranchising more voters than we're trying to enfranchise by changing the rules. So that makes sense, right? But it turns out that what constitutes voter confusion and what is too close to election day are just very much in the eye of the beholder. So for instance, in 2018, there was a case in North Dakota that 6 months before election day struck down a voter ID law requiring residential addresses. So basically North Dakota has a huge Native American population. Reservations don't have kind of traditional street addresses you can put in an ID. And so for about 6 months, everyone was proceeding as though they didn't need an ID with a residential address. And then 6 weeks before election day, the 8th Circuit stayed the district court's injunction. Supreme Court signs off. So 6 weeks before election day, suddenly voters are trying to figure out how to get this kind of ID that for 6 months they'd been operating under the assumption they didn't need. So this cycle, we've seen sort of similar things happen during primary season. So in Wisconsin, district court and circuit court allow ballots postmarked after election day to count, so long as they're received within a few days of election day. The night before the primary election, the Supreme Court steps in and says, nope, you've got to postmark by election day. And in Florida, for months, district court's injunction about felon reenfranchisement has been in place. And then 3 weeks before the voter registration deadline, the 11th Circuit stays that ruling, Supreme Court signs off. So I'll just close by saying I am actually very sympathetic to the idea you have to lock the rules at some point. I've worked on a few campaigns where there's been active litigation near election day and it is total chaos. And I, having clerked at the court in an election year, it's really tough. You're dealing with really knotty legal problems on an expedited timeline. But the Supreme Court, I think, needs to do a little bit more to justify these decisions in public-facing writings, because otherwise it's just all too easy to have it look like we stay injunctions that make it easier for Democrats to vote in swing states. And I hope that's not true, but the only way to combat that misperception is to say just a little bit more about why some decisions are getting stayed and why in some cases the Supreme Court is staying out of the fray.
Thank you. I just want to add one more case that's on the docket for the coming term to the discussion. It's Fulton versus City of Philadelphia. Philadelphia contracts with social service agencies to foster care placements, to place children in foster homes. And Philadelphia says that in order for a social service agency to do these placements, the social service agency can't discriminate based on race, sex, religion, sexual orientation. Catholic Social Services wishes to place children in foster care, but refuses to place children with gay or lesbian foster parents. It says it won't recognize, because of its religious beliefs, gay or lesbian marriages. The Catholic Social Service Susan says they deny it the ability to participate in this program on account of its religious beliefs, violates its free exercise of religion, and also its freedom of speech. It says we have to attest that we don't discriminate, and that would be compelled speech. The Supreme Court has granted a review of the case. I think it's enormously important because I think we have a conservative majority now that wants to facilitate the ability of individuals, businesses, employers to discriminate on account of their religious beliefs. The issue was before the court a couple of years ago in the Masterpiece Cake Shop. The court didn't reach the issue, but now it might. Also, the court has before it the question of whether to overrule a 1990 decision, the landmark ruling in Employment Division versus Smith, which said that religions don't get exceptions from general laws. If the court overrules that decision, it will again facilitate allowing people-based to inflict harm on others, including in discrimination. So with that, we've left 10 minutes for questions. There's lots of questions. We're not going to be able to get to all of them, and I apologize. Let me just try to scroll to the very beginning if I can. Well, let me start with the first one on my screen. It's from James Costello. I'm struck by the article in today's Washington Post that Judge Barrett signed a newspaper ad in 2006 declaring, quote, "It's time to put an end to the barbaric legacy of Roe v. Wade and restore laws that protect the lives of unborn children," end quote. Given Judge Barrett's writing on the diminished importance of stare decisis on issues of constitutional construction, this tends to erode the claim made by many senators that just have no idea how Justice Barrett would vote on Roe v. Wade. Do we think there are 50 Republican senators willing to be seen in an election year as much more directly voting to overturn Roe? Does anyone on the panel want to take that up? Oh, I won't ask Goodwin as a sitting justice, but Bertrall or Amanda or Easha?
I guess I'll say something briefly. I do think it's unlikely that the court will directly overturn Roe v. Wade. I think that the more likely tact will be to chip away at it. And so I think that Erwin's right, that June Medical would likely have been decided differently if Barrett was on the court. And I think similar cases like that will limit access to abortion will be on the agenda in the initial period. And once they have chipped away, once access has been chipped away at, then Roe v. Wade might be more of a target, or it might be unnecessary to target at that point, because abortion in many states, or in some states, will be essentially unavailable. So that's kind of my thoughts on it. And I think that there are probably still 50 senators willing to vote for her. I think that, there have been concerns about previous nominees, but, Susan Collins and others who may have expressed qualms and complaints end up voting for that confirmation because it's too central to the Republican enterprise.
I agree with Bertrall's conclusion. I think there's going to be 50 senators who are going to vote to confirm Amy Coney Barrett. I can't count to 4. It would take 4 who would vote to oppose. But I'm much less sanguine than you are, Bertrall, about overruling Roe. I think Chief Justice Roberts would vote to chip away at Roe. But I think when it comes to Thomas, Alito, Gorsuch, and Kavanaugh, they very much want to overrule it. And based on all we know about Amy Coney Barrett, I think there's the 5th vote. That said, I hope you're right and I'm wrong. Does anybody else want to speak to this before I go to the next question?
I have very little to add, except for that I actually agree with you, Erwin, in terms of predicting the future. I have to say, when this came out in the news, I was quite astounded that she signed this with judicial aspirations in the balance.
Well, let me take another question from Jonathan Singer. In light of the increasing rightward lean of the U.S. Supreme Court, do you see a likely increase in the new judicial federalism as embodied by the late Oregon Justice and Berkeley Law alum Hans Linde that is more pushing of progressive legal theories in state courts to effect change? Goodwin, if I can ask you your views on, will this mean more turning to state constitutions and state courts? Goodwin, I think you're on mute.
I think he might be frozen.
You might be frozen. Do others want to answer that question?
I'm happy to speak to that if you would like. Both Goodwin and I have written and spoken about Judge Jeff Sutton's book. And so I won't speak for Goodwin, but I think we came to similar conclusions, which is that Judge Sutton, who's written a book about I think it's 51 Imperfect Solutions, the Constitution, he's written a book that has encouraged people to think about state constitutional law and to go to state courts to further whatever their purposes are. He's not a progressive himself. And I think that there's a lot to be said for that. There already was, and now if the court does take an even greater right-hand turn or shift to that direction, people should be thinking about the state courts. People should be thinking about the fact that there are many situations in which state constitutional law can give greater protection. For example, in the Fourth Amendment context, among other areas.
Goodwin, I see you're back. There's a question when you were frozen about whether you think the Supreme Court becoming increasingly going to lead to more turning to state constitutions and state courts.
Yeah, I suspect there might be. It should be noted that Hans Linde was a great alum of Berkeley Law. We count him also among the giants of the legal profession whom we lost this year. I think that, ever since Justice Brennan wrote the thesis in 1977 about judicial federalism, advocates have been searching really for footholds in constitutional law in the states to achieve gains that they were unable to achieve in the federal courts. I suspect that will continue. I would also note, though, that it's not just litigation in state courts. I mean, here we are in California, where the governor of this state has just announced fuel efficiency standards for cars that far exceed federal standards. And I mean, there are all kinds of ways that in our federal system the states are going to, I believe, show some variation, and California is just the kind of prime example of ways in which both legislatively and judicially there are ways of achieving certain advocates' goals that go above a federal floor.
Easha?
So maybe to give a sort of concrete example of what Professor Tyler and Justice Liu have been talking about, at the MacArthur Justice Center, we have a civil rights appellate program. And, starting before Justice Ginsburg's passing, we have been working to launch a program that's specifically going to focus on the state Supreme Courts. Historically, we've litigated mostly in the federal courts of appeal. For the next generation or so, that's not looking like a super favorable environment for prison conditions or police brutality or criminal defense cases. And so we're starting with a project to take a look at the almost 20 state constitutions that have 8th amendments that are different and in some ways more capacious than the federal constitution. So as Justice Scalia noted in Harmelin, a case about whether the 8th Amendment protects against disproportionate sentences, the federal constitution conspicuously doesn't say disproportionate in the text. It says cruel and unusual, but not disproportionate. But many state constitutions have an 8th Amendment equivalent that bars disproportionate punishments. Many state constitutions also don't use the term punish or include a synonym to the term punish, which helps get around the kind of really strict mens rea requirement that the Supreme Court has imposed for bringing claims under the federal constitution. And so in both prison conditions and sentencing cases, we're going to be looking to kind of push the envelope of where state constitutions can extend broader protection than the federal constitution. And I think that's just one example of a lot of laboratories that are happening in a lot of different civil rights organizations around the country right now.
I think we have time for a couple more questions. I'm going to combine them. Bertrall, both of these go to the Affordable Care Act, which you discussed. And my screen just shifted, so I lost one of them. Proponents, supporters of the ACA in Congress can save the law of the Supreme Court framework by raising the tax from 0 to a penny. What are the chances? This is from Nira Castillo McIntyre. If I can scroll, we had one other question on the Affordable Care Act, but I lost it on my screen.
Oh, no worries. I was answering them in the Q&A, so I don't know if it disappears when I send an answer.
Oh, okay.
It might or might not, I don't know. So, I mean, that is a possible response. I think that if Biden won the White House and Democrats can control the two houses of Congress, I think they're going to want a little bit more than that. I think they're going to want a little bit more than just reviving the individual mandate and preserving the constitutionality of the Affordable Care Act. I think that there will be a push for something more. But I think that it is a way to insulate the Affordable Care Act if you believe that the court is going to use the case not to revisit NFIB v. Sebelius, but rather to address the constitutionality of the amended shared responsibility payment. My fear is that they're going to use it as an opportunity to revisit NFIB v. Sebelius and to strike it down as not even being a permissible exercise of taxing power, even if the shared responsibility payment is set at 1 penny or more. And if that's the case, then it puts us back at ground zero. A lot of individuals will lose their health insurance, and we will need a new health plan to provide for the insurance of people that may be better than what we have with the Affordable Care Act.
All too quickly, the time for this program has come to an end. I hope you'll join me in thanking Easha and Goodwin and Bertrall and Amanda for their really terrific presentations today. And thanks to all of you for joining us. I wish we could be in person, but I'm so glad at least we could do it this way. Thanks, everyone.
Thank you.
Thank you, everyone.
Thank you.